right, I see that we have everyone with us. Mr. Donovan, my understanding is you are the appellant in this proceeding, and did you wish to pardon me, reserve some time for rebuttal?
Yes, Your Honor. 5 minutes for rebuttal, please.
Okay. I have made the notation, and I will attempt to get as close to the 15-minute mark as I can to let you know.
Thank you, Your Honor.
You may proceed, counsel.
May it please the court. For the record, Chris Donovan here on behalf of the appellants, Judith Delgado, Cheryl Rogers, and the School District of Collier County. The matter before this court presents two significant issues of statewide importance. The first is whether the proper method of for non-parties to seek review of discovery orders is by final plenary appeal as the first and the third and the fifth DCA have reached, or by non-final certiorari review as this court has reached. The second is whether or not the Sunshine Law has abrogated the attorney-client privilege for government agencies in every case, in all situations, including for meetings not governed by the Sunshine Law, such as those between agency's attorney and their staff. Absent objection, I will address these issues in the order that I just presented them.
Well, before you do, Mr. Donovan, I have a concern regarding the second issue.
Okay.
In order to get to the second issue, does not the commentary have to be within the protection of attorney-client privilege?
Yes, it does, Your Honor.
And so if it's not, then it doesn't really matter what the second issue is. And my understanding is that people that may assert the claim of attorney-client privilege, but nevertheless may be a fact witness, and you can't hold out from being a fact witness by a claim of attorney-client privilege, that the law would require you to disgorge the information that you know without disgorging, if you will, your communications with your attorney. Is that correct?
Well, it depends on how you, yes. I mean, certainly if it's a fact witness, but in terms of the specific questions that were being posed at the deposition concern the communications between Ms. Delgado and Ms. Rogers, or well, the particular deposition was Ms. Delgado and the school district's general counsel. So, and I believe that there were questions posed as to her just general knowledge and her general work with charter schools and her position. But the objections that were raised were directed at the conversations concerning Ms. Delgado and the school district concerning the investigation into Mason Academy that the school district or the school district's general counsel was performing at the direction of the superintendent.
Were these witnesses disclosing the information to counsel for the purpose of legal advice, or is our record silent on that point?
The record is silent on that point because that issue was never raised by the Mason Academy below. In fact,
who is seeking to invoke the privilege?
We sought to invoke the privilege, but it was
Would
presumed.
that mean that you needed to do something to establish the existence of the privilege, your client?
I believe that it was established on the sheer fact that on the face of the questions, it was involving the performance of legal services that the school district or the school district's attorney was performing. There was no question that the questions that they were asking were otherwise satisfying the
question. I guess the concern I have is that there's a moment between fact work product and attorney-client privilege, and I'm trying to see on the scale whether when someone says the attorney said I got these facts, that's a different analysis for disclosure of those facts than attorney-client privilege, which would arguably prohibit that disclosure. So the recitation of facts may be fact work product, may not be attorney-client privilege is my concern.
I'll be honest with you, Your Honor, this is, to a certain extent, a lot of this conversation is going well beyond the briefs and well beyond what they raised below. They assumed that the arguments or that the questions they were asking otherwise qualified. Their only objection below and the trial court's only conclusion was that the school board or the school district lacked the ability to protect any confidential communications. Assuming that is the case, what happened here, they assumed it was, but they argued that they...
If I may, Mr. Donovan,
sure.
And to bring you back to what you've alleged, if you're taking the position that these employees are in fact protected by the attorney-client. So the question for me in terms of analyzing this, who is the client here? Wouldn't you agree that it's not the employees, but the school board itself is the client here?
With respect, I think that the school district is technically the client. Under the Constitution, Article 9, Section 4A and B, the school district is the government entity. The school board is the governing body. The superintendent is an executive official, and the employees carry out the day-to-day operation of the school district. So the school district itself is technically the client.
And I guess my question then, if, okay, the school district, the school board, if we have the existing, and you see what's been alleged in the brief by the appellees, that based on the current law, they cannot, because of the sunshine law that we have, they cannot claim any attorney-client privilege. So how can then we jump and leapfrog into these employees to now say, well, they're protected by the attorney-client privilege? Help me out with this.
Because the privilege protects the communications. And the only basis for saying that the school board as the governing body cannot have attorney-client privilege communications with the school district's attorney is because of the sunshine law requires any communications between the two of those groups or between the school district attorney and the school board must be in public. But simply because it must be in public under the sunshine law. But section 90.5026, its plain language says that if the discussion or activity is not a meeting that for purposes of section 286.011 or for purposes of the sunshine law, then it does not waive the attorney-client's privilege in this section, which encompasses public bodies or organizations such as the school district. In other words, if the school board's attorney is providing legal services, which can be, it doesn't have to just be authorized by the school board. I mean, a principal could call the school district's attorney and ask what's the proper legal method under the Florida statutes for expelling a student. The school board is typically not involved in that conversation. That doesn't have to be it's not a sunshine meeting because it's between a staff member and the school district's attorney, which is also a staff member. So it's a private conversation that is entitled to protection under the privilege. Just because the entity, as the Mitchell versus School District of Leon County, just because the entity cannot protect communications, the governing body cannot protect communications with the school district because of the simple fact that those communications have to occur at a sunshine meeting, doesn't mean that the staff members or the lower level employees who are carrying out the day-to-day operation of the government, who needs to oftentimes seek advice as part of the legal services. It's the whole purpose of having a school district employee is not just to advise the decision makers of the entity, but also to advise those the executive staff members and the other staff members who carry out the operation of the government. In fact, it would be quite significant. I think this is reaching a conclusion like the trial court found, and with respect, like your Judge Kuzam's question asked, would have significant impact on the operation of government and the ability of school district attorneys to, agency employees to seek advice on how to carry out their job within the confines of the law by seeking that advice from the school district's attorney. I mentioned the example of the principal, but it could be even outside of the school board context, because the Sunshine Law applies to every government entity except for maybe the Florida legislature. It's quite broad. It applies to all state agencies. It applies to all political subdivisions, including local governments like cities, counties, water management districts. A ruling such as the trial court here in finding that simply because the entity's governing body lacks the ability to speak confidentially at a private meeting, absent the very limited exception under the Sunshine Law for litigation privilege, would prevent protection of well, prevent the protection of lower level employees from being able to seek advice from the legal counsel.
And Mr. Donovan, but couldn't the flip side be argued too, that there's a danger that it would also be violative of the Sunshine Law if people could thwart that by saying, hey, we'll have these meetings, we'll have to be able to talk, and then somehow they would, if there's some discussions made privately and then come back to a full open meeting, doesn't that also have the effect of thwarting the Sunshine Law? So it could, the flip side of it could also apply. Wouldn't you agree?
No, Your Honor, with respect, I wouldn't, because I mean, as the decision in Knox versus School District of Brevard, where it specifically said staff members aren't governed by the Sunshine Law. And that's not the only one. There's Bennett versus Warden, which is from this court, that staff members aren't governed by the Sunshine Law. That same concern you have would obviously exist if staff members aren't governed by the Sunshine Law. And the reason why it's not a concern is because it doesn't actually involve the school, the collegial body, or the final decision makers of the given political entity. That's the only thing that the Sunshine Law is intended to protect. It's intended to ensure that at the final point that a decision is being made, policies can be talked about by staffs. They can even have individual conversations, like individual school board members can have conversations with their staff outside of the public, because the public the Sunshine Law doesn't protect those discussions. They can come up with all sorts of policy decisions, but the actual voting or the actual discussion by the decision makers has to be in public. And it's the sole reason why the Supreme Court in Noy versus Miami Herald reached the conclusion that it reached, and didn't specifically discuss Mitchell, but it specifically only concerned those instances where two or more members of the same collegial body must meet with their general counsel. In other words, when a Sunshine Law will apply. And in that instance, the Supreme Court in Noy said that, for the obvious reason that it's in public, it can't be kept confidential, that those conversations would not be covered by the attorney-client privilege. But the
Mr.
concurring—
Donovan, I would be remiss, since you were kind enough to address my question first, if I failed to remind you that I pulled you off your first issue, and as you're at 12, I want to make sure you didn't lose that first issue argument that you wanted to make. So I'm trying to make kind of balance off the thing I took you off. I want to get you back where you were, if that's what you wish to do.
Well, I appreciate that, and I certainly want to go where the concern is the biggest, and that's where your honors are asking questions. And I'm happy to stand on my briefs with respect to that, because with respect to the jurisdictional issue, because I think irrespective of whether this court considers it under the plenary review as the first, third, and the fifth DCA have, I think that, or certiorari as this court has historically, I think that the trial court has departed from the essential requirements of the law, or otherwise violated the law, given the plain language of 90.5026 limitation that the Sunshine Law only invades the attorney-client privilege when the discussion or activity must be at a public meeting, or it's not, or is a meeting under section 286.011, and of course violates the first DCA's specific holding, decided 25 years earlier on exact same facts as presented in this case. But to go back to the point, the Noy versus Miami Herald, the Justice Overton and Ehrlich's concurring opinion noted the limitations of that decision, that it was not applying to meetings that did not apply to that were not governed by the Sunshine Law, such as meetings between, like, the mayor and the city's attorney, or the superintendent and the superintendent's or the school district's attorney. So I believe that my understanding is that, I mean, there certainly would have been an easier way to state that there is no privilege, right? I mean, they could have, in section 90.502, which specifically references government public entities or public organizations, or rule 4-1.6, which does the same, that could have just simply been removed. Instead, the Florida legislature, after the Attorney General's opinion that made the logical leap between what Noy said and then saying, well, if the governing body lacks the privilege, the ability to have the privilege, then no employee can have as well, even if it's for furthering the government services. The Attorney General the legislature 2 or 3 years later is what enacted the 90.5026 to ensure that if it isn't covered by a sunshine meeting, then the protection can still exist if the other elements of the privilege is satisfied. Here, the other elements, going back to Judge Casanueva's point, here the other elements of the privilege were never challenged. The objections were made as to the privilege. The only response to countering that was you don't have a privilege because of the Sunshine Law, and then we were off to the races, and that was what was discussed to
And
reach.
speaking of off to the races, we're a little bit past 15, and I want to protect your rebuttal time. So
Thank you,
that's
Your
up to
Honor.
you whether you want to go forward or not.
I will reserve at this point and ask this court to reverse the finding that the public records, or excuse me, the Sunshine Law has destroyed the attorney-client privilege in the government sector.
Thank you, counsel. Let me stop the clock here so we get back to 0. Okay, Mr. Brannick, you're back at 0, so you have your 20 minutes. The clock was not running on you.
Morning, Your Honors. May it please the court, I'm Steve Brannick of Brannick, Humphreys and Berman, representing the respondent Mason Classical Academy. I'll start with something I agree with that Mr. Donovan said, which is that the result in this case isn't any different whether it's an appeal or a petition for certiorari. And I say that because to the extent that there's an academic issue about the right standard of review, I just want to emphasize this is not the right case to resolve that academic conflict. This is already the second interlocutory appellate proceeding that we've had in this case. And the last thing the parties need to do is to head up to the Florida Supreme Court on an academic issue. So let me dive right into the merits. The fundamental principle of the attorney-client privilege when it comes to corporations and organizations is that the privilege is owned by the organization, not the individuals. That's 90.3023A. And that's the decent case and the many cases that talk about the exercise of the attorney-client privilege in an organizational context. So the question comes down to here whether the school board has an attorney-client privilege to assert. And I call it the new case. I don't know whether it's new or Noy, but the new case answers that question. It states specifically that the attorney-client privilege is owned by the client, that the client is the school board. And because the school board is subject to the Sunshine Act, everything it does is public. And because it's public, there can't be any confidentiality. And because confidentiality is one of the pillars of the attorney-client privilege, there can't be any attorney-client privilege. As the Attorney General's opinion 9761 correctly concludes, that ends the matter. If the school board is the client and has no attorney-client privilege, then its employees can't have an attorney-client privilege because their privilege is derivative. It's as simple as that. There's not a single case after New that decides to the contrary. And I think it's very important that New's been around for 35 years. The Attorney General opinion has been around for 25 years, and the legislature has not intervened. Mr. Donovan has made a lot of public policy arguments. Those public policy arguments always get raised in these issues, and the courts always say that the question of how we balance an agency's ability to operate with the Sunshine Act is a matter for the legislature, not for the courts. And the legislature has chosen not to step in. They rely heavily on the Mitchell case, but of course the Mitchell case was decided before New, and Mitchell did not address the question that we have in front of us here, whether there is in fact an attorney-client privilege issue that can be even asserted.
So,
They also rely.
Mr. Bragdon, let me then jump in, and based on what you've indicated, let me jump in because I think Mr. Donovan has gone forward and said, well, let's look at Florida statute section 90.502. That section, as you know, provides that a communication between lawyer and client may be deemed privileged from disclosure if it was, and I think the language, if it was made in rendition of legal services to the client and is intended to be confidential. So my question to you here, okay, let's just assume everything that you said is correct. Now, jumping in, was there anything in the record provided other than just a generalized argument, attorney-client? Was there any showing in the record that any communications with Ms. Rogers, Mr. Delgado's, with the Mr. Fishbane were made in connection with the rendition of legal services? Was there anything like that in the record below?
Yeah, absolutely not. And that is, of course, our big second point in this case is that there's just no record that the attorney-client privilege exists here. If you look back at the Delgado deposition, the questions are at 28 and 29 of that deposition. The first question is, did you have any conversations with the district general counsel? Then the second question, and then the response to that, counsel says there was a pending investigation. That is the record that we have here. There was no discussion about what sort of legal advice was being sought. There was no discussion about whether Mr. Fishbane was acting as an attorney in connection with this investigation. Investigations are conducted by folks all the time, not necessarily by attorneys. The question is, was there any legal advice in connection with that? There's certainly nothing in the Delgado investigation, the Delgado deposition that would address those two fundamental building blocks of the privilege. Now we then move to the motion to compel and their motion for protective order. They actually filed an affidavit of Ms. Delgado in connection with their motion for protective order. It doesn't say a single thing about confidentiality. It doesn't say a single thing about the rendition of legal advice. It just talks about the fact that she thought she was intimidated by the fact that several folks from Mason Classical Academy were in attendance at the deposition. So they certainly had their opportunity in the trial court to make that record.
Mr. Rennick, let me phrase my question in this manner. If the ruling was, as you say, there's no evidence in there, well, the trial court's correct ruling would be that there is no evidence to establish privilege, rather than privilege doesn't apply in this broad situation of character cases. That the trial court should, like we, make the most narrowest ruling as possible. And here is, there's an assertion of attorney-client privilege. There's no record evidence to support the assertion. Therefore, the claim is denied, rather than the analysis of, well, hey, the public record law, open government, that's the basis. Did the trial court rule too broadly?
I think the trial court could have ruled either way. I think maybe my philosophy of judging would be that you decide the case based on the record first, and if there's no record, you don't have to reach the kind of the bigger legal policy question about how New applies, how Mitchell applies. But we did, in our motion to compel, suggest that they had not met their burden of proving the privilege. If you look at the appendix, page 61 in our motion to compel, we say that the enumerated matters don't qualify for the privilege. So we did raise that issue. The trial judge could have gone either way, but now we're up in front of this court on an original proceeding, and there's absolutely no doubt that they have the burden of showing that there's a material injury, and they have a burden of showing a departure from the essential requirements of the law. The only way they can do that is to demonstrate that there, in fact, is a factual predicate for the assertion of the privilege, and they have not done that. They could have filed those affidavits that could be part of their appendix in support of their petition for writ of certiorari, but they didn't do that. So we've got nothing in the record that shows that what Mr. Fishbane did was in connection with the rendition of legal services. We've got nothing in the record that suggests that this was intended to be confidential. First, let me talk about Mr. Fishbane. He's an attorney, and that's the best thing they've got going for him. But as we know from the attorney-client privilege in the corporate context, general counsel sometimes acts as an officer, and sometimes they act as an attorney. And so it's very, very important, and the cases all emphasize this, that if a general counsel is going to claim privilege in connection with a particular conversation, there has to be a showing in the record that the general counsel is in fact acting as an attorney in connection with the rendition of legal advice, and not just as an officer. And again, all we know here is that Mr. Fishbane conducted an investigation. He didn't need to be an attorney to conduct that investigation. He happened to be an attorney. But what the record doesn't show is what was the legal advice that was requested or whether there was any legal advice requested at all. But maybe the easiest way to decide, this is on the second prong, which is whether there was an expectation of confidentiality. Because we know that there couldn't have been because this Fishbane report was published. We know that there was nothing confidential about this. All of his findings from whatever sources were published. There's no reference in the Fishbane report to any hidden confidential information that for whatever reason was withheld from the public. So there's no record whatsoever that Ms. Delgado and Ms. Rogers disclosed anything to Mr. Fishbane under some sort of expectation of confidentiality. So the bottom line is they just can't carry their very high burden in this court of showing a departure from the essential requirements of the law because they just don't have the factual predicate. So that kind of gets me back to the elements of the petition for certiorari, which is you have to prove material injury. And again, the simple point here is that if there was no expectation of confidentiality and there's nothing in the record that suggests that confidential information is at stake, how in the world is there any material injury? How in the world are they entitled to a petition for certiorari? So for all of those reasons, we believe that this court should deny the writ.
I don't see any further questions. Thank you, Mr. Brannick. Mr. Donovan, you have your 5 minutes remaining, sir.
Thank you, Your Honor. I would like to emphasize, I think, 3 points. The first is I was not stating that the first issue is academic. I mean, it really kind of depends on how this court rules on whether or not 90.5026, which has never been ruled on by another court after the Noy and Mitchell decision, whether or not this court were to do as it does in some other instances, find that, well, there hasn't been a case interpreting it, so the trial court's decision is not a clear departure. It's also not academic, given that it affects the stay rights of the school board or of any public entity. So I certainly was not suggesting, I said I stand on my briefs, but I was not suggesting that this is a purely academic question, but it actually has a real.
Let me, while you're on this point of an academic question, allow me to propound one as well. If this court were to reach the conclusion that the record was insufficient to establish a claim at this stage of the proceeding of attorney-client privilege, and on that basis agreed with the trial court, but disagreed with its expansive ruling, how would that be viewed in terms of, would that be a plenary result? Would that be denial of a cert because there's no material injury? The ruling is right, in a sense, for the wrong reason.
I
and you don't have to take up much time. If you want to say you want to think about it, move on, feel free. Because obviously
I
was
will think
thinking out
about it
loud
and
as
try
well.
to circle back around to that, because that's an interesting question, but I certainly think that it does play into the jurisdictional conundrum in this case. I do want to
Well, if
highlight.
there is no attorney-client privilege established on the record, how then can the trial court say that the law on public meetings applies? I mean, you got to have A before you get to B, at least my view.
Well, with respect, A was presumed, Your Honor. I mean, it really
Well, I don't
was.
like the word assume because I know when you break it down what it says.
I said presumed, not assumed.
Presume,
but,
okay.
But it was. I mean, this actually was one of my points, is that opposing counsel highlighted that they did raise the concern that the attorney-client privilege elements were not met. He referred to page 61. He's talking about paragraph 49, but I want to emphasize it says, for starters, the communications do not concern the enumerated matters that qualify for exemption. In parentheses, he's referring to the litigation strategy or settlement negotiations. He's talking about whether or not they qualify whether or not they qualify under the Sunshine Law for being able to have discussions in private. It had nothing to do with whether or not the actual communications between Delgado and the school district were in rendition of legal services. That was never raised below. And I guess to go back to Your Honor's question, the jurisdictional certiorari is a much more liberal area, or much more easier area for the court to say, well, this was right for the wrong reason, or maybe this particular record isn't clear enough, so we're not going to decide it. Which is all the more reasons why, although
We can
waiver
use
works,
Dixie Coachman on a plenary appeal too, so don't worry.
that's true, and
All
waiver
right,
works
you don't
as
have to
well.
work out all the bugs here. You have a limited time to worry about it. And I guess the panel has a little bit more time than you have available. So don't forget your other 2 points.
Fair enough. Well, the second one was the one that I just mentioned, that correcting the record that they did not raise this below, or this particular point on meeting the elements of privilege. It was assumed that this was privilege. It just didn't apply because of supposedly the Noy decision and the AG's opinion. And with respects to those two, this leads into the third point, and that is that the opposing counsel suggested the legislature could have spoken to this and could have jumped in and corrected any confusion out of Noy and the AG's decision. Well, they did in 90.5026. I don't see how they could have made it any clearer to say that a discussion or activity that is not a meeting under the sunshine shall not be construed, which is what the trial court did. It's what the AG did. It's what the Masons Academy did throughout below, but shall not be construed as a waiver of the attorney-client privilege. So it really comes down to, does the Sunshine Law apply to the meeting? If it does, then obviously it can't be protected, and attorney-client privilege, there's no expectation of privacy within the government entity. If the Sunshine Law does not apply, as it does not apply to staff meetings or otherwise, otherwise meetings that do not involve 2 or more members of the same collegial body, then the attorney-client privilege can apply when the elements are met, which they are met here, because this issue was never raised below. It would be a due process violation to suggest that we have to defend this particular issue on appeal for the first time. But in an actuality, this was a service being done, legal service being provided by the school district's general counsel in investigating this. It doesn't require authorization from the school board first. The superintendent powers are broad enough to delegate that, to have him investigate and apply the facts and determine whether or not the charter schools, the particular charter school here, Mason Academy, is violating the law, and whether or not there should be a recommendation to the school board on terminating that contract. Therefore, I respectfully request.
Okay, you're doing it. Go ahead.
I respectfully
summing up.
request
That's good.
that this court first find that the trial court erred, but also go further and suggest that this should be decided on a plenary review and either certify conflict or certify a question of great public importance, or revisit its prior decision in bond. Thank you, Your Honors.
Thank you both.
Thank you. Thank
You
you.
all
both.
stay well. We'll see you again soon.
Sounds good.
Take care. Bye-bye.